Hello and welcome to the Prince Live. Today we are discussing how the Supreme Court's order during the day in the Jammu and Kashmir petitions will help in easing restrictions in the troubled valley. Just to understand and give you a lowdown of what happened in the court primarily is there were 14 petitions before a CJI-led bench, of which Justice S.A. Bobde and Justice Abdul Nazir were also a part of. Among the 14 petitions, the petitions can be divided into three categories. One, which challenges the constitutionality of the presidential order, which deoperationalized Article 370 therein, which also led to the bifurcation of Jammu and Kashmir as union territories and not states. Secondly, the second part of the pleas were about the information blackout, and which challenged the information blackout in the state of Jammu and Kashmir, for which the journalists were facing a lot of problems in filing stories or making calls to their respective editors to Delhi or somewhere else. And the information blackout has also caused a lot of problems to the people of Jammu and Kashmir, especially the ones who were trying to avail medical facilities or roam around in the city to pay heed to their local needs or daily needs. The third petition was a bunch of habeas corpus petitions in which one Jamia Millia Islamia student and one Mr. Sitaram Yechuri, a CPIM leader, had petitioned the court that they wanted to, one of them, Mr. Yechuri, wanted to meet a fellow MLA in Srinagar, whereas the Jamia Millia Islamia student had not had a conversation with his parents since August 4th. And he was really worried about his parents, and he wanted his parents to be produced before him through a habeas corpus petition. So these were the broad contours of the pleas which were there before the Supreme Court of India. However, today, just to set the record straight, the Supreme Court has ordered that all the pleas which were primarily filed by Shah Faisal, Shala Rashid, the National Conference leaders, a Kashmiri advocate, another Delhi-based advocate, among others, had filed these pleas challenging the constitutionality of the presidential order which deoperationalized Article 370. And in that specific order, the Chief Justice has noted that a 5-judge bench would likely hear the case as a constitution bench in the first week of October. And the notice was also served to the Centre and Jammu and Kashmir administration. Apart from this, in the case where the habeas corpus petitions were filed, a landmark thing happened. Both of them were allowed to travel to Kashmir. Mr. Yachuri was allowed to travel to Kashmir to meet his friend, and the Jamia Millia Islamia student Muhammad Aleem Sayyed was allowed to go to Jammu and Kashmir to meet his parents. However, the court has noted that an affidavit has to be filed in the court immediately upon their return, so as to show what transpired between them meeting their respective parents and one meeting the MLA in Jammu and Kashmir. So that was an addition to the Supreme Court's order allowing the habeas corpus petitions. And in the third set of petitions which challenge the information blackout in this state, if we just remember clearly, during one of the last hearings, while hearing Anuradha Basan, the editor of Kashmir Times, plea about the information blackout, the court had noted that we should give a certain amount of time to the state and to the union government to resume normalcy in the area. However, today the court gave a week's time to Jammu and Kashmir administration and the central government to respond about when is it planning to completely give or to lift away all the restrictions in the valley, especially the ones that were causing problems to the journalist. Ms. Bhasin has stated in her plea that her paper, Kashmir Times, was not being able to be printed in the valley because of the restrictions imposed on journalists for filing stories, etc. And essentially it curbed the freedom of press in the country, which is also one of the enshrined rights under the Part 3 of the Constitution. So we would be looking at your questions. One of the questions that we have now is, why do you think the court did not lift it right away? I think, Mansa, who is raising this question right now, you mean that why did not the court lift the media restrictions and restrictions in the information blackout? So let's understand that in a little broader perspective. When the information blackout was imposed, if the Supreme Court today says that we lift it, then at one point of time it would be seen as an undue interference, or it's the terminology in court is also used as judicial overreach. especially because the court cannot go ahead and lift the restrictions right away before knowing what the state has to say. However, one point of argument can be there that a 7 days, it has been forced from the 4th of August. Now we are on the 20, we are in the 27th of the month, and it's been close to 21, 22 days since this information blackout is persisting, and it was around 1.5 weeks back. The court had said we need another 3-4 days for the situation to gain normalcy in the area. So considering this, and considering the fact that the government has already started opening schools, though the schools were empty and the attendance were dismal, but however, nonetheless, the government had started opening schools, primary, secondary, etc. The court must have felt that it would give some time to the union government to respond as to when it's lifting the restrictions altogether. However, a 7 days time indeed would be seen as a delay tactic or a delay mechanism by the top court of the country. On September 3rd, this matter would come up again before the court, and then the central government is expected to file its reply about when is it going to completely lift the restrictions in the valley. So Siddharth Chaturvedi has a question for us. Does the present scene in the Supreme Court reminds us of the ADM Jabalpur case? Well, ADM Jabalpur case was one of the landmark cases which was delivered during the period of emergency, and was strictly in relation to detention. Here, when we speak about 400 leaders, I think you also by this question mean the political detentions that have taken place in the valley. It's as of today around 400 leaders are still under detention. So indeed the court will look at this particular case of ADM Jabalpur also, because when the constitutionality of Article 370 has been challenged in the court, this is one of the cases which might come up as one of the cases by the petitioners before the court, stating how the rights were infringed during the emergency in the ADM Jabalpur case, especially in relation to the detention. So we need to look at this aspect also. Amol Singh says, did SC define which situation is to be called normalcy? No, Mr. Singh, the Supreme Court did not define what is the situation of normalcy, neither did it define what do we mean by normalcy, because the court was not going into the merits of the case. The court only wanted to give the Union of India some more time to start schools, to start hospitals, to allow communication, to allow travel. However, today when the court has given another 7 days time for the Union government and Jammu and Kashmir state administration to respond, this indeed is being seen as a delay in guaranteeing rights to the people of Jammu and Kashmir. So just to answer your question, the court did not get into the definition of what normalcy is. The court took the definition of normalcy at its face value and considered it as something which will lift the restrictions in the valley. Basu has a question for us. Are there chances that the Modi government rolls back its August 5 decision? Well, there are no chances for the government to roll back its August 5 decision, unfortunately, because the government is already in the process of appointing the GOM for the state of Jammu and Kashmir. There are also talks about appointing the lieutenant governor in the state, and the government has also stuck to its point of the presidential order that it has issued. To answer you more specifically, the government of India cannot go back on its Kashmir issue or the deoperationalizing Article 370, because when a presidential order has been issued to this effect, there needs to be a very clear-cut intention expressed on behalf of the government that it wants to roll back its decision. Indeed, it's one of the major decisions in the Modi government has taken in the last 6 to 7 years of its tenure. So there is unfortunately no chance that it's going to roll back its decision. However, the decision has been challenged in the court of law on the basis of its violating the Constitution of India. Govind has a question for us. Please conclude for us if the court has authority to remove the law created by Parliament. Yes. When you say that whether the court has the authority to remove the law created by the Parliament, I would answer you completely in legal terms. The court has all the right in its capacity to strike down a law created by the law of by the Parliament. In fact, if it violates the basic structure of the Constitution, if it violates the fundamental rights guaranteed to individual under the Constitution, or if it violates any provision of the Constitution of India. However, we also have to note that the contention that a law made by Parliament is something that a law has to be passed by the Parliament. So a Jammu and Kashmir reorganization bill was indeed passed by both the houses, and that's what has been challenged along with the presidential order. And if you recollect the NJAC case, if we recollect the there are a couple of other cases which is not coming right now to my mind, but the NJC was one of the most important cases which we might talk about, because it was one of the government's pet dream projects of appointment of judges, which was struck down by the Supreme Court as it was violative of the Constitution, and it ceases to exist as of now, and we have gone back to the collegium system. So just to answer you, the Supreme Court has the right to strike down that law. How are these notices against constitutionality? I don't think I get your question. How are these notices against constitutionality? Are you saying that the notices that were issued by the Supreme Court to the petitioners? Well, I don't think no one is questioning about the constitutionality of the notices, because issuing notice to the centre or to the Jammu and Kashmir State Administration is a very, very common procedure according to the court of law. Whichever plea you take to the court of law, the first step that is often, if the court of course is not dismissing your plea outright and sees merit in some of your submissions, the first step the court of law would do is to issue a notice to the central government or to the concerned authority involved, and because issuing a notice means you have to take notice of the plea and send us a reply, and on the basis of that we would be continuing the argument. So this is a common procedure of law, and there is no question of constitutionality involved in this one. There is a question by Sunil J. Does this stance of the court mean that they feel personal freedoms of citizens are dispensable? This is a very, very controversial question, because today, as of now, the court has not taken any stand by which we can say that the personal freedoms of citizens are dispensable. Neither the court has made any statement, nor the court has passed any order to this effect. The court has only issued the notice to the central government and the Jammu and Kashmir State Administration as to seek their response on the plea of challenging the constitutionality. When we talk about personal freedoms of citizen being dispensable, this is a broader question of law which will be dealt with. It has been dealt before also in several full bench judgments of the Supreme Court of India, in which has been held that the personal freedoms of an individual is certainly not dispensable. However, there are reasonable restrictions, and the reasonable restrictions are enshrined within Article 19 of the Constitution, and this reasonable restrictions are often the grounds which is argued by the defense or the prosecution, as the case may be, to justify why the personal freedoms of a particular individual were sacrificed or were tampered with at that point of time. So this is a broader legal argument that will be put forward to, and as of now nothing on this your question has happened. Hopefully in October, when the Constitution bench argument begins, sees the light of the day, this question will indeed be one of the primary questions before the court of law. A witty kid is your name perhaps. There's a question. Is there a possibility of the government completely removing restrictions if the court says it needs to be done? Yes, of course. Again, like the court has all its power to strike down a law passed by the parliament, it also has all the power in the world to direct the state administration to lift all the restrictions in the state of Jammu and Kashmir. However, there is this very important point of national security threat and law and order. Now, these are the two subjects on which Solicitor General Tushar Mehta will try to persuade the court to not do such a thing at a very hasty instance, and perhaps that is the reason why this 7 days have been given to the state to send a reply. As the Chief Justice of India is known to dispense of cases very fast in his courtroom, number one, there is a chance that if the centre does not reply in 7 days, the CJI might lift the restrictions in his own right, but that would be counted as a judicial overreach or anything else which tampers with the central government decision of national security, and that is perhaps this time gap and the time window has been given for the government to reply. Just to add to your question again, is that Justice Solicitor General Tushar Mehta during the arguments told the Supreme Court not to issue a statement in this case, because he said that this entire case has been internationalized, and he said that whatever he says in the courtroom today might be used in the United Nations, etc., against the country. However, the court said that it has applied its mind and it's already passed its order and it's not going to change it. So from this particular interaction in the court, it will give you an idea what the government of India is thinking at the moment. And I think the government of India at the moment is only trying to paint a picture before the international community that Kashmir is indeed an internal matter, and hence it was also trying to guard and caution the Supreme Court of not saying anything which would or might jeopardize its case before the international body. Sunil Dalmiya has a question: why the court should not view situation in Kashmir as an attempt to foist Islamic Jihad in India at the instigation of the evil government of Pakistan? See, again, the question before the court was not this. The question before the court was certainly not whether Islamic Jihad was a problem in Kashmir or it was done at the behest of Pakistan. The question before the court was the presidential order of 5th August, which made Jammu and Kashmir a union territory and also extended the entire constitution of India to the state of Jammu and Kashmir, was indeed constitutionally valid or not. Let us all remember that the 1947 Instrument of Accession, which India signed with the then King of Jammu and Kashmir, Mr. Raja Hari Singh, that Instrument of Accession was the link of connectivity between India and the princely state of Kashmir, which was then cemented by the Presidential Order of 1954, which gave them their autonomous status and also allowed them to have their own constitution. This order, which was passed on 5th August of this month 2019, in a way deoperationalized that entire order of 1954, and in a way also went against the Instrument of Accession, and that is what is the contention of the petitioners. So this is the broader case before the Supreme Court of India. The Supreme Court of India is not looking at the problem of Islamic Jihad in Jammu and Kashmir, or whether it's being done as the behest of the evil government of the government of Pakistan. These are not the questions before the court of the law. Junaid Farid Khan has a question: what happens when the case is shifted to the 5-member bench? Well, Junaid, when the case goes to the 5-member bench, as you are aware that a 5-member bench is now hearing the Ayodhya case in a constitution bench hearing. So I'll just tell you in layman words, a constitution bench is only formulated when a matter of constitutional importance need to be heard and ordered upon in the court of law. And when this 5-member bench starts deliberating on the constitutional challenges to the deoperationalization of Article 370 and the presidential order which was passed on 5th August 2019, it will look at whether this act of the government of India indeed harmed the basic structure of the constitution, and the basic structure of the constitution rests upon the federal relations of our country between the state and the center. So these are some of the crucial questions which will come into place. The questions also before the court will be whether the governor, whether the president's power to issue this order was a colorable exercise of power. Now, colorable exercise of power is something which we talk about when you are not allowed to exercise that power, but you exercise that power in the garb of a position or an authority. So that colorable exercise of power will also be a point of question before the court of law. Gagan Saini has a question for us: is there any precedence? To courts' interference in ongoing law and order issues of this magnitude? When the court has time and again indeed interfered when there has been grave law and order situations in the country, whether, if you remember, during the time of the bifurcation of Telangana and Hyderabad, the Supreme Court had intervened. Even during the times of, there were problems in Maharashtra, there were problems in Tamil Nadu, grave law and order situations, the Supreme Court had always intervened, either, has passed an order through additional security measures or lifted restrictions. If you remember the time of Jallikattu, in Tamil Nadu, it had led to a huge amount of protests and a lot of law and order situations of that magnitude when the government, when the Supreme Court of India intervened in that matter and tried to reach a resolution or to try to resume normalcy in the area through its orders. So this is perhaps not new for the government of India to venture into such a question. However, such a question of law detailing with the 2019 order of the Supreme Court of the government of India is indeed a very new matter before the court. However, we should not lose track from the Keshav Nanda Bharati case also, which was before the Apex Court, which dealt with the basic structure doctrine, etc., to which this argument which will happen in court will also draw its genesis from these arguments as well. We have another question from Mr. Mushtaq Mughal. He says, is it not a failure of the Supreme Court dispensing speedy justice? Justice delayed means justice denied. Mr. Mughal, I think if the Constitution bench starts its hearing and gives a judgment after, say, 2, 3, 4 years, and even then the curfew or the impositions in the state continues, then I believe your question will be valid. However, now when the court has given a 7-day, I was talking about this, a 7-day gap might also be seen as a huge amount of delay. But the problem is, if the court directly lifts the restrictions in the state of Jammu and Kashmir, it will be easily termed as an act of judicial overreach, because this is something which the government of India has done and tried to justify in the court of law as it was in the interest of national security and integration of India. So unfortunately, before the court of law, these two factors are very important, are very heavy. So when we talk about these two factors and these two these two options of national of security, national threat, etc., from the neighboring nations, then in these kind of situations, the court has to take note of it with an iron hand. And in these cases, we might have to be a little patient when we are dealing with the top court of the country, because immediate orders are always not issued when such matters of grave constitutional importance is involved. I think we have dealt with more or less all the aspects of today's hearing in the Supreme Court on Jammu and Kashmir. The focus will now obviously shift to September 3rd, when the government has to reply when it's going to make the streets of Jammu and Kashmir free of consortia, wires, and how the journalists wouldn't have to haggle in that one room with 4 desktop computers to file their stories every day. So the ball is now in the court of the government of India to inform the court when it is going to lift the restrictions and how it is going to go about it. And the deadline is only 7 days, hopefully not to be extended any further. We at ThePrint will keep you informed of all the latest developments in the case directly from the Supreme Court of India. This is Devan Roy for ThePrint.